Fingerprint to do it. I just wanted to know what that meant, but I think it's a fingerprint. On the record, in the matter of the people of the state of Michigan versus Paul Anthony Ledesma, file number 23-01309. Appearance for the record.
Jeff Rodos on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Paul Desma.
Okay, today was the date and the time that was set for a jury trial. I do have a offer here. It says that people are offering for the defendant to accept responsibility for a civil infraction of careless driving.
And then we would also, I forget, but I know we would dismiss count one at that point, Your Honor.
We don't need this for a civil infraction. That's for sure. You accept responsibility?
Yes, ma'am.
Okay. Fine is, I'm sorry, this is cause an accident? Counsel,
No, Your Honor. Didn't know.
the fine is $210. Are you able to pay today?
Yes.
Okay, we'll get you over to the criminal traffic counter and then you'll be all set. Any additional matters for the record on this file?
Nothing from the people, Your Honor.
Nothing for the defense, Your Honor.
Give me just a moment. What are we doing? It's a final retrial on the PA-53. Do we have any hearing? On Mr. King? Okay. Yep. On the record in the matter of the people of the state of Michigan versus Deveron Anderson, file number 23-01540. Counsel appearance.
Jeff Rodos on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Devari and Anderson.
This is Devarian.
Devarance.
Devarian, your pants don't go up on top of your butt.
Yes, ma'am.
Okay, you didn't wear them that way, especially when you come in my courtroom. Okay, I don't want to see your underwear. Today's the date and the time that's set for a final pre-trial. Are we proceeding to trial?
At this time, Your Honor, as you stated, today's the date and time set for final pretrial. The people have subpoenaed witnesses. And to the best of my knowledge, I've called the hallway in the courtroom. Those witnesses have not appeared. So at this time, the people would be unable to proceed.
Okay. Mr. Lee?
Since the people are unable to proceed, the defense would make a motion to dismiss.
Motion to dismiss without prejudice is granted. So the case is going to be dismissed today. That without prejudice means they do have the right to reissue the charge against you if the necessary witnesses re-engage with the prosecution's office within the statutory time frame and they're ready to proceed. You understand that, sir?
Oh, yes, ma'am.
Do you have any questions about that? You can ask your counsel to confirm the statutory time frame for that. And then any no contact orders, you would need to give us 72 hours to remove all that information from lien, okay?
Okay.
Okay, you can have a seat. We'll get you a copy of your dismissal.
All right, thank you.
You're welcome. Okay. Oh, it's Mr. Milks on a Monday.
Count your blessings, Your Honor. This is exciting.
How are you, sir?
I am lovely. How are you?
Okay, let's see. On the record in the matter of the people of the state of Michigan versus Jesse Cochran, file number 23-01713. Counsel appearance.
Jeff Rodos on behalf of the people, Your Honor.
Hey, good morning, Your Honor. Stephen Notes on behalf of Mr. Cochran, who is present and standing to my right at this time.
Today is the date and the time that was set for a final, excuse me, pre-trial on one count of assault with a deadly weapon, also known as felonious assault. Do we have necessary witnesses here?
Your Honor, I believe, just for the record, that was amended to a misdemeanor complaint of assault and battery.
Oh, that is correct.
However, yes, the people have the necessary witnesses here and are ready to proceed. We have made an offer for Mr. Cockrum to plead as charged to the assault and battery with an offer for no upfront jail with that. However, I believe the defense is not inclined to accept that, and we would be proceeding to trial. However, I would leave that to Mr. Mills to confirm.
Mr. Mills.
Thank you, Your Honor. Yes, that is a complete and accurate statement, Your Honor. We are rejecting that plea offer at this time is essentially just plead guilty to the charge as is, so it's not really an offer in this matter, Your Honor. And yeah, we do suspect taking this trial. I believe we can complete it in one day. I believe the defense will have at least one witness that we will call. When would the court like jury instructions?
Just the Friday before.
Friday before?
It's scheduled for jury trial September 11th at 8 o'clock in the morning. Do we have anything as priority to that day? We might have an older case that might bump you. I don't want you to come and get upset.
Yeah.
We do have some cases set for jury trial that might bump you if those witnesses appear. If not, we'll be proceeding with your matter on September 11th. No problem. Any questions at this time?
Nothing for those people here.
Nothing from the defense. Thank you, Your Honor.
Okay, you're all set, sir. Thank you. On the record in the matter of the people of the state of Michigan versus Miles Washington, file number 23-01501, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
And Assistant Public Defender Sarah Dowling on behalf of the defendant, Miles Washington, who is present and standing to my right.
Okay, Mr. Washington, how are you? Date and the time. That's set for final pre-trial. There is a PA 53. Okay, if there was a PA 53, that he was arraigned on, so that should have been set for today as well. How are we proceeding?
Yes, Your Honor, as you stated, today's date and time set for final pretrial. I've called the hallway in the courtroom, and I believe at this time the people's subpoena witnesses have failed to appear, so at this time the people would be unable to proceed.
Ms. Donnelly.
Thank you, Your Honor. I believe those are the same witnesses for both the PA 53 and for the underlying charge, so I would ask that both be dismissed without prejudice.
That is correct. So the PA 53 violation will be dismissed. And your motion to dismiss the domestic violence is granted without prejudice. So that means that they have the right to reissue the charge against you if the necessary witness is ready to proceed and moves forward within the statutory time frame. Do you have any questions, sir?
Yes, what is that conference?
Did you hear the last person ask that? No, you didn't? Okay, well, your attorney can talk to you about what the statutory time frame and what implications that have for you, okay, sir? No worries. We'll get you a copy of your dismissal. The no contact order that's in place, you need to give us 72 hours before we can pull all that information out of lien before you would go into any exclusion zones or make any prohibited contact under your original bond order, okay? So give us time to give us that, and then we'll get you a copy of your dismissal. You'll be all set in just a moment, okay? You can have a seat. Is that ready for me to sign, Mr. Brodowitz?
Yes.
Yes. And then there's another one. I think he's bringing Mr. King up.
Yes.
And we have Cruz Borrego here.
Yes, I'm ready to go with this.
Is Mr. Cadet here?
Yes.
Yes.
Mr. Cadet's here.
Chair President.
Yes. Thank you.
Get that, you okay?
Yeah.
No, I didn't.
Yeah.
I didn't.
People don't go up to jail no more, huh, Mr. Mills?
Hmm?
You guys don't go visit your clients in jail anymore, huh? Wait till they come to court.
Guess we're trying to make a habit of it, Karen.
Not all along. Back when I was a public defender, we went to the jail.
Now we get polygraph.
Look at that.
I feel like I'm walking into
Let us
something
go to
here.
the jail.
I'm gonna get something for her.
Well, I think you can arrange your visit via Polycom. They have a right for that. I know that it's not a requirement for you to wait for them to come to court to talk to them. Do you have anybody ready to go, Mr. Lee? Are you representing Mr. Cadet?
I am.
Okay, on the record in the matter of the people of the state of Michigan versus Alerte Cadet, file number 23-00158. Council appearance.
Jeff Braddock on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Alert Day Cadet.
How are you, Mr. Cadet?
Okay.
Okay, today is the date that's set for sentencing. This matter proceeded to a jury trial, which you were found guilty of assault and battery. I didn't refer you to probation, which typically I would refer you to probation for them to do a screening and provide me with a pre-sentence report and recommendation as to how you should be sentenced. I didn't do that in this case because of the circumstances surrounding the underlying incident. I did not have any indication that would make me believe that I would put you on probation based on those circumstances. So counsel, I'll let you make allocation before I proceed with sentencing.
Thank you, Your Honor. Mr. Cadet is a hardworking man, provides for his family, he works 2 jobs. He gives back to his community on the weekend and the work he does as a minister. In many ways, Mr. Cadet is an example of what we want. In this particular case, he accepts responsibility that he probably made some bad choices in terms of how he dealt with things. And he's expressed some remorse to me for this. It's been a difficult time for him, but given his character, I know that he will come through the other side of this a better man for it.
Okay. Mr. Cadet, did you want to make a statement at all on your own?
The incident, I just got out from 18 hours and 10 hours from my job and 8 hours for my second job. I got out at 12 o'clock. That incident, any man will come to this incident that want to drove a car and then come into the house and then the wife got out and then sitting at the same car. You didn't see her when she got out and you get in. And the TV very cold, and she told me she was watching the TV. And when I called her, where you at? She said that she's sitting in my car. And I said, how come you sitting in my car? Where you coming from? She said she was coming from out of the house. And I said, how come I walk through? There is no tree from the house. There is nothing to back for her coming out and coming in. I didn't see her. And I already have suspicions she has a secret life. And I've been lived here for 8 years and waiting for her coming. After 8 years, I bought her here. And I have nothing, how she's managed her life overseas. But only suspicions, because I have nothing to argue with, and I hold everything until I got the truth. She has an affair with her own supervisor. And I saw with my own eyes, she coming out of the driveway. And I thought any human beings, if you married with a woman and then she has no friend in this area and you have no clue, she just coming out. Although I heard it, I wait she come and with some explanations what she been doing and her own supervisor coming out of the driveway after work. She never did anything and I travel overseas and this thing on my mind until the second time. And then I saw her on a shopping parking lot with him. I didn't go at the same time. I wait until her come in my house. And I tried to confront her. And I said, what is going on? For me, is my daughter coming and recording my voice on my private conversation with my wife. It's totally against the law. In my own house, no one can be, filming or recording my voice. And I asked her, you need to go to your house, to your bedroom. So this is a private conversation. The next thing she asked me to get out. She told me, you need to get out and then let my mom live with her boyfriend. And I said, it's not gonna be happening in my own house. I want you to this house. When I live here, you're not even born. And when I live here, your mom was overseas. I live here and I brought you guys here. You have no right to ask me to move out in my own house. Then I pay bills. That's why I didn't ask you to pay bills here. And I asked you to save your money because there's a time you're gonna handle your life on your own. After that days, she come again and then she told me, so they need you to move out because we keep talking about the subject and every man gonna get upset when you have a wife, have a secret life, and then try to lie to you and get upset, throw bad word on you. And then she come and told me, hey, you need to move out. No one wants you here. And I tell her, you out of this conversation until the last day. And she, she asked me, okay, I'm gonna explain you what happened, when you come get me and then I already in your car. And then when we started that conversation, she just coming out of the bedroom. So soon I opened the door and then coming in, and then she's coming up, from upstairs and coming to downstairs. We were downstairs. And my wife said, hey, go back to your house, to your bedroom, so no one wants you here. Although she's still working downstairs and already have her phone ready on camera and then get me on camera. And I was sitting on the couch when we began to argue, and I said, I give up. There is no way we can discuss this matter this morning because she's already involved. And I told her, hey, you need to move out. Now you're a dog. I'm not responsible for nothing for you. And I tolerate you to stay here if you behave. Now, your behavior, I can tolerate it. You need to move out. And if you don't have to move on your own, I have to call the police. But I just pressure, I'm not gonna call the police for my own daughter because we have some disagreement on some subject. And then when I just tried to left and then struck me and called me, oh man, stupid old man. And I turned back, I said, what, just call me. It's in my own language. I said, just hold Zimla. Next thing she hit me on my phone here. my front head, and she hit me in my mouth. You know, the sound my wife jumped. She jumped on my foot. That's something. So I try to teach them, defense 101 because I am a CJ graduate with a bachelor, and I try to teach them how to defend themselves. If anything happened, they have to self-defend. And then she's practiced this on me. And I have several months before I can work on my foot properly. This is what was going on. I didn't put pen on my daughter, and I will ever that this is my daughter. This is my only one. So I have, no matter what behavior she had, she's very aggressive. I know. And if you make an investigation, so how she was behaving at school, it was very terrible. She never can handle a job. She never stayed at school for 1 week without coming back. And she not even go the high school on one high school. I hope she's transferred to a different section school, Eastern, to finish it. And every single week they call me and then come get her because she can stand this life. And then kick and yelling, swearing, and
So she was having behavioral problems.
Oh yeah.
This is one thing that I overheard, or that I picked up during the jury trial. Again, you were found guilty by way of jury trial. However, her testimony, your daughter's testimony, she indicated, and the video demonstrated, to corroborate what she said, was that she wasn't going to wait for anybody to hit her. She took the first blow. She said that. You said the same thing you said today, essentially on the stand, without giving all the background about what was going on with your wife. You did share this similar rendition of what happened, and then your wife took the stand and said you didn't touch your daughter. I don't know what went on in the jury room. That wasn't for me to determine. I didn't determine the facts, but they did find you guilty. I found it to be an unfortunate situation because it's a family, and it's a daughter and a father and a wife all involved in this heated verbal situation that escalated. From what I could see from the video, you tried to take the phone from her when she was recording. Nonetheless, it's an unfortunate situation. I don't think that this is a situation that requires me to put you in jail. That's not going to remedy the situation. I don't even think putting you on probation will remedy the situation. I think this is something you probably need to make some decisions about who's living in your household to remedy that situation. And for your own protection at this point. Okay, because where you are now, it's not safe. And you've indicated even at the time of the trial, you work a lot of hours. And even what you shared today about what's going on with you and your wife, she still took the stand and she was very clear. My husband didn't touch my daughter. And you can see on the video where she's telling the daughter to stop. She wasn't telling you to stop. So from my vantage point, it sounds like maybe the jury could have gotten it wrong, but nonetheless, the jury decision is the jury decision, and that's final. With that being said, I am going to sentence you to the crime victim rights fee only, and I'll waive discretionary fines and costs. So that's $75. When can you pay that? I'm sorry?
Yeah, I appreciate it. Oh, today, yeah.
Okay, we'll get you over to the criminal traffic counter and you can make payment, and good luck to you, okay, sir?
Thank you so much, Ron. I understand.
Are you ready with Mr. King?
Yes, sir.
Okay, on the record of the matter of the people of the state of Michigan versus Trevor Anthony King, file numbers 23-01578, counsel appearance.
Jeff Prados on behalf of the people, Your Honor.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Trevor King, who is present and standing to my right.
Okay, today was the date and time that was set for a final pretrial. Then we had a PA 53 violation. Do we have a witness here?
As you stated, Your Honor, today's date and time set for final pretrial. People have subpoenaed witnesses. I've told the hallway in the courtroom, and those witnesses have not appeared. So at this time, the people would be unable to proceed.
The PA 53 involves
Newer
Picking up
case.
a newer case, but also consumption of alcohol. Did you subpoena a witness here for the alcohol consumption?
I do not believe so, Your Honor. Not sure about the alcohol consumption, Your Honor, but we did also subpoena witnesses for the PA 53, and as far as I am aware, neither of those witnesses have appeared.
Who was subpoenaed for the PA?
It would be with Officer Christine Childs, Lansing Police Department, and the victim in this matter, Mr. Daryl Fields.
I did not know that the PA 53 involved the victim. I see consumption of alcohol and I guess picking up the new charge. Nonetheless, Ms. Donnelly, how do you want to proceed?
At this time, Your Honor, we would be requesting dismissal without prejudice.
Okay, your motion to dismiss without prejudice is granted. The PA 53 will also be dismissed. We'll get you a copy of your knowledge. Either the prosecutor or your attorney can advise you as to what the statutory time frame is. But the without prejudice means that during that statutory time frame, the prosecutor does have the right to reissue this charge against you. Do you understand that? Okay, do you have any questions? Okay, we'll get you a copy of your knowledge in just a moment. You're welcome. Yes. On the record, we don't have a prosecutor. Where would he need to go? Where would he need to go?
It was also set for restitution. We did stipulate to restitution.
What was that for restitution?
Borrego also.
Okay, on the record in the matter of the people of the state of Michigan versus Cruz Castro Borrego, file number 17-04314. Appearance, please.
Thank you, Your Honor. Assistant Public Defender Sarah Donnelly on behalf of defendant Cruz Borrego, who is present and standing to my right.
How are you, Mr. Borrego?
I am doing
I'm doing well. Today is the day that was set to proceed on a sentencing on one count of stolen property. 2,000 but less than 1,000. There's also supposed to be a restitution hearing. I have a restitution form here in the amount of $6,500. Are you stipulating to that amount, counsel?
Believe I am stipulating with Mr. Brodowitz to an amount of 3,800. That was what was conferred to me. There was emails last week about proofs and establishing fair market value, and that's so that's what he asked, is if we would stipulate to that amount. We did.
3,800.
Yes.
You can make allocation.
Thank you, Your Honor. After reviewing the pre-sentencing report and recommendation with Mr. Borrego, we don't have any objections to the recommendations for probation and community service and continuing with rehabilitative services. It's been 6 years since this offense. Mr. Borrego has been honest and accountable about what the kind of situation he was in back then with drug addiction and what he was doing for that drug addiction. But in the 6 years since, he has made amazing strides. And now he leads a life where he is not in trouble with the law. He has steady employment. He has supportive family. Oh, you just got married, yes. So I think he's really turned it around, Your Honor. I don't believe that this sort of thing, or he will be going down that road and path any longer. And if he does, and if it starts that way, he knows. You've learned the tools, Mr. Borrego, to what to do in the event that if it ever becomes a temptation again, correct? All right, so 7 years clean, Your Honor. So with that, again, we don't have any recommendations to the recommendation, or the recommendation. We just ask that the court consider that he is agreeing to pay restitution. So if there's any discretionary court costs the court would waive, we would appreciate it. Thank you.
What programming or recovery tools is he actively participating in now?
You said you have counseling, or do you?
Oh, I go to, yes, I got my therapist with Cherry Health Clinic. And then I do 4 times a week on NA meetings. I have a sponsor, I go to church.
Go to church locally.
My wife.
Hi. You go to church locally. Locally. Catholic church locally. Okay. And you're working, you're employed. I actually completely disagree with the recommendation, to be honest with you. Since it happened in 2016, I don't see where you've been engaged with the criminal justice system since then. So I don't see why I would put you on probation. You just need to pay the restitution.
Okay, Your Honor. I right now I don't have the money to pay.
I don't expect you to have $3,800 in your pocket. You can make payments on it.
Thank you so much.
I'm waiting for the prosecutor to come in confirm that 3,800 is what he stipulated for. I don't know why he's missing for so long. Nonetheless, again, I do see where clearly prior to 2016, you've had some engagement with the criminal justice system. Literally, it's consistent with what was stated here today. It looks like these were probably actions that you were committing to further whatever substance abuse issue you were dealing with. But there's nothing since 2016. It's almost 2024. Sentence you to impulsive control course 7 years later. I think probably took care of that already, no? If you don't, I think the lady that's sitting here waiting for you is probably helping you with that. So at this time, Mr. Brodowitz, I need to know what the stipulated amount of restitution is.
So there was a stipulated amount of restitution in this matter, Your Honor, to $3,800 that was extended to the public defender's office here.
Okay, so I will amend the restitution form to $3,800 paid to Rodolfo Gayton, and the address is listed here. You can make monthly payments. There's also a $75 crime victim rights fee plus a $50 state minimum cost. That'll be assessed. I'll waive discretionary fines and costs. And you'll make monthly payments. How much can you afford to make monthly?
I can pay up to $50 a week.
When are you gonna make your first payment?
This week coming. Yeah, well, yeah.
By Friday or next week?
Friday.
Okay. Friday is the 20th. Okay, I'll note here that the defendant will make payments of $50 per week beginning August 25th. You can come up, make them right at the criminal trafficking window, or you can mail check or money order. You would just attach this case number, or you can go online and make payment at the court website. You would also use your case number, which is the 17-04314 number, okay? Do you have any questions at this time?
I don't care.
Any additional, no problem. Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing for defense, thank you.
Your
Your Honor? Yes, sir.
Was there an updated report in Carrie? I don't believe Mr. Lee or myself.
For Carrie?
Yes.
These are no. We need to start. These right envelope. These are all old. May 1st. Did you all contact the forensics on this one? I'll contact forensic for updated report on this.
One item. You know, it's only one item, it's 2 items.
She's asked if we had updated, or they asked if we had an updated report.
That's why it's not hard, Sarah.
Yeah.
That amount of money, you could have covered one item. So, other items. Well, it's not-
Mr. Coleman, you're here for the dog bite case.
Yeah, my Zoom's updating right now, Your Honor. I went to speak from this purpose.
Yes, Your Honor.
Okay, the prosecutor's Zoom is updating, and then
Okay.
he's gonna log in to speak with you privately.
Okay, great. Thank you.
Host has open break rooms. Please wait to be assigned.
Wait, mute. I see a person identified as Morgan Frederick.
Yes, ma'am. I am the BCBA for Flat Rocks regarding Daniel Carey.
Okay, we are looking into that matter as we speak because we don't have a report.
Yes, ma'am.
Looks like he was seen August 2nd and they're still working on the report. So I'm gonna reset this a couple of weeks because we should have one by then.
Yes, ma'am.
No?
She would email the doctor and said you wanted it by the 18th.
She's gonna say I want it by the 18th of September.
Yeah.
Oh, okay, we'll set it out. That's fine. We'll set it out 30 days. They'll get it to us by September 18th.
All right.
If not,
Is it still at
if not-
9:30, ma'am?
Let's see.
They can get it to us by September.
I'm sorry, I didn't hear you.
It said they can get it to us by September 18th.
Yeah, or if not before.
That must September 18th.
No, that he
Okay.
was different.
Okay.
They
and
just
then
said it when-
We can set it for the
He was
18th.
nine.
Okay, we'll set it for the 18th at what time? At 18th at 9:30.
All right. Thank you, ma'am. You have a wonderful day.
Same to you. I don't think they're on my docket.
If I could speak.
Matthew Lyons, are you ready with, are we
I-
ready with King or
I
does
believe
Mr.
Mr.
Coleman need to
Coleman
speak?
needed to speak with his attorney or with his client.
Okay, Mr.
Um,
Coleman, did you need to speak with your client?
Yeah, just briefly, Judge. I need to fill him in and we're probably going to be good to go then.
Put him in your room. You can just return to room 1.
Thank you.
And then, at that point as well, I need to, yes, I do need to speak to Mr. Lyons and then Mr. Merle Phillips. Logs in.
Mr. Lyons, can you hear me?
Yes.
Okay, do you have an attorney?
I do not know.
Okay, well, the prosecutor's gonna come speak with you privately, okay?
Okay.
Mr. Coleman?
Yeah, Your Honor, I didn't get the invite to the room. Sorry.
Oh, you will get another invite because you're already in the breakout room. You should see
Oh,
breakout room on your screen and you'll just return to room 1.
I'm not.
Look,
seeing
it's on my screen, breakout room is down on the bottom, but it might be down on the right for you.
Oh, I see breakout rooms. Okay, that's funny. Thanks, Judge. Sorry.
No problem. And Mr. Brodowitz, let me move you to room 2. And then I'm gonna put Mr. Lyons in room 2. Okay, who's on the Samsung SM? Good morning, sir. Can you hear me? Hello,
Mr. Phillips?
thank you. Okay, Mr. Phillips, you're representing yourself, correct?
Yes, ma'am.
Okay, when Mr. Brodowitz is all set, I'll get you in a meeting room with him next, okay?
Thank you.
You're welcome.
Here I am.
Hello?
Here I am.
Hello?
Lewis King speaking.
Yep, this is Merle Phillips.
Mr.
Lewis,
Phillips, he's not speaking to you.
Oh,
You okay?
yeah.
Mr. Broderick is on his way back. Yes, but it looks like Mr. Coleman's ready to move.
Okay.
On the record, in the matter of the people of the state of Michigan versus Lewis King, file number is 23-01049, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Morning, Your Honor. Dave Coleman appearing on behalf of Mr. King. He is also here by Zoom.
Thank you. Today was the date set for a pretrial on one count of dog bite. How are we proceeding?
Yes, Your Honor. At this time, the people have made an offer for the defendant to accept, responsibility to a civil infraction in this matter of impeding traffic. And the fine that is, and then the people, and I believe the defense would add, or at least the people would ask that this matter be set out for a restitution hearing just for an additional 30 days to allow the people to attempt to get into contact with the victim and see if there is any restitution in this matter.
Okay. Pick your date for the restitution hearing. Does September 11th work for you, Mr. Coleman?
Let me check, Your Honor. What was that date again?
September 11th At what time? At 8:30?
Your Honor, I'm in a jury trial all week, circuit court on the 11th. The 18th is clear if that works for the court.
September 18th.
September 18th at 8:30 is fine.
Thank you, Your Honor.
No problem. And your client wishes to accept responsibility to the impeding traffic?
Yes, Your Honor.
Okay. The fine in that civil infraction is $125. Is he able to make payment today?
Yeah, how, does he need to come in person, Your Honor, or is it something?
He could pay online at the court website. He would use his case number, the 23-01049, or he
Okay.
can mail check or money order to the court and attach that case number as well. Or he would come up in person and make it at the criminal traffic window.
Okay, if it's okay for him to mail it, he had talked earlier with me about that. That would be great, Judge.
Okay, sounds good. And then we'll see you all for the restitution hearing. Any additional matters for today?
Nothing from the people, Your Honor.
Nothing from us. Thank you, Judge.
You're welcome. Thank you.
Mhm.
Okay, let's see. And you are ready with Mr. Lyons?
Yes.
On the record in the matter of the people of the state of Michigan versus Matthew Eugene Lyons, file number is 23-02163, council appearance.
Jeff Radowitz on behalf of the people, Your Honor.
And then Mr. Lyons is present via Zoom without counsel. Mr. Lyons has one count of dog at large. How are we proceeding, counsel?
Yes, Your Honor, at this time, after speaking with Mr. Lyons, Mr. Lyons has provided the people with compliance and shown me through Zoom how he is taking steps to secure the dog. He's also informed me that there are further steps that he will be taking in the future to ensure the dog cannot escape the yard anymore. And so with that, the people are satisfied. The people made an offer of compliance. The people are satisfied with that compliance. The people would ask that this ticket be dismissed for compliance.
Motion to dismiss is granted. This citation is dismissed, Mr. Lyons.
Thank you.
You're welcome. You're all set.
All right, have a good day.
Have a good one. Okay, you need to speak with Mr. Phillips.
Yes, I believe he's also unrepresented.
Correct.
And the only other one I think I would have this morning would be Mr. Nicholas Stone. If and when he gets on.
Okay.
Unrepresented.
We have some 1030s. They're gonna log them on. Is that what's going? Are they downstairs?
Garza and
Okay.
Okay. Yeah.
Do they need to speak with their attorneys?
I'm good with Garza. I spoke to him previously on, I'd like to speak with Miss Hunter because she's interested.
Okay, we'll have her brought up now.
Yeah.
Lipcott. Mr. Brodowitz, we do have Mr. Richard Lipcott here. Did you extend an offer on Reese Martin already?
Yes.
Okay, sounds good. Good morning, Mr. Lipcott, Lippett, I think it is.
Good morning, Your Honor.
Okay. Is your client gonna log in separately?
He is, and I just hung up the phone with him. I know our hearing is for 10, but I would expect that he's probably gonna log on any second now.
Okay, sounds good.
Do you want to take care of that?
This is in jail.
Okay, what about Mr.?
Oh, boy. Not two of them.
All right, that's Ms. Hunter. Okay, I need.
I'm ready to go with Mr. Phillips.
Okay, on the record, in the matter of the people of the state of Michigan versus Merle William Phillips, file number 23-01720, 23-01721, 23-01725, 23-01726, and 23-01727. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
And Mr. Phillips is present via Zoom without counsel, and he's met with you privately. We have several counts here of dog vaccination and licensing, and I think one. Nope, that's not him. How are we proceeding?
Yes, Your Honor, at this time, after conversations with Mr. Phillips, he has informed me that he no longer has the dogs Echo and Nala. And he has provided me a proof of licensure and vaccination for the dogs Brody, Sampson, and Kiera. So at this time, the people are satisfied with compliance and would ask that the matters be dismissed for said compliance. Or the ticket be dismissed, or tickets be dismissed for said compliance.
I think they were all on a citation. Let's see. They were, the motion to dismiss in each file is granted. These matters are dismissed, Mr. Phillips.
Thank you, Your Honor.
You're welcome. On the Moto E6. Ma'am, what's your name? I can't hear you.
Jessica Gonzalez.
Okay. Jessica Gonzalez, who's representing Ms. Gonzalez?
I'm representing Mr. Gonzalez, Your Honor.
Okay, did you need to speak to her? Are you ready to proceed?
I have, I need a brief conversation.
Okay, I'll get you in a private meeting room. And then I see Mr. Martin is present. On the record in the matter of the people of the state of Michigan versus Reese Joseph Martin, file number 20-00497. Appearance, please.
Jeff Brodowitz on
Your
behalf of
Honor.
the people, Your Honor.
I apologize. Good morning, Your Honor. Richard Lippett on behalf of the defendant, Reese Martin. He appears here on Zoom.
Say was the date and the time that was set for a pretrial on one count of assault or assault and battery. How are we proceeding? Was there an offer in this?
Yes, Your Honor. At this time, the people have extended an offer for Mr. Martin to plead to an added count 2 of disorderly person drunk. And with that, the people would dismiss count 1. I'm not sure on how Mr. Lippett wants to proceed with his client, so I would leave that to him, Your Honor.
Mr. Lippett?
Yeah, I received that offer. I've discussed it with my client. My client wishes to avail himself of that offer. I just moments ago went over his rights to trial with him, and he does stand ready to offer a plea.
Okay, Mr. Martin, is that correct? You want to accept the offer at this time?
Correct, Your Honor.
Please raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury.
Yes, Your Honor.
Thank you. You can put your hand down. Okay, Mr. Martin, in order for you to accept the offer to plead guilty to an added count 2 of disorderly person drunk, you would have to understand your rights and then give those rights up. One of those rights, sir, is your right to a trial. So you have the right to a jury trial and you have the right to the presumption of innocence at the time of that trial. So you're innocent until proven guilty. You have the right to have the prosecution prove your guilt at a trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to confront in court any of the witnesses they intended to call against you, and you have the right to cross-examine those witnesses or question those witnesses. You have the right to call your own witnesses to trial or present evidence at trial that you believe further a defense to the charge being brought against you. You also have the right to remain silent at trial and not have silence be used against you. You understand each of those rights?
Yes, Your Honor.
And are you willing to give up each of those rights in order to accept the offer to plead guilty to disorderly person drunk?
Yes, Your Honor.
Is anybody making any promises to you or threats to get you to want to waive those rights and enter a guilty plea to the amended charge?
No, Your Honor.
Okay, are you currently on probation or on parole?
Yes, I am on probation out of the Marine City, Your Honor.
Okay, you understand that by pleading guilty, it could result in a violation of your probation status?
Yes, Your Honor.
Okay, you also understand that by a guilty plea, it could result in a conviction that you may need to report to your current employer or to a future job opportunity. You understand that?
Yes, Your Honor.
Then also, it could have an impact on any travel or immigration status that you may be seeking. You may not be able to visit Canada or any other place that prohibits people with convictions from visiting. You understand that?
Yes, Your Honor.
You still want to give up your rights?
Correct, Your Honor.
Okay, as to the added count 2 of disorderly person drunk, do you plead guilty, not guilty, or stand mute?
Guilty, Your Honor.
Are you pleading guilty because you believe you're guilty?
Yes, Your Honor.
Okay. Counsel, can I have a factual basis?
I apologize, Your Honor. This case is sort of quite old, and I'm wondering if the assistant prosecutor can assist me with that.
Do you have a police report?
I do not.
Okay. Did you
We would
receive discovery?
stipulate to the
Well,
facts as set forth in the police report.
Did you receive discovery?
I have not, Your Honor.
Okay. Okay, well, then I'm not accepting a plea, because how do you advise your client to plea if you've not reviewed the discovery and determined his rights had not been, and determined whether or not his rights has been violated?
Well, I've discussed with my client at length what his conduct was on the evening, and he doesn't deny what his conduct was. So
his conduct is the only reason for a motion to dismiss? You don't think his rights could have potentially have been violated at that time if you reviewed this discovery? Or do you not know because you don't have the discovery?
I don't have the discovery, Your Honor. I'm wondering if the people can provide it to me by email, and we could go back on the record in a few minutes.
We're gonna not go back on the record in a few minutes. I'm gonna reset this matter because I think you had a professional responsibility to get the discovery before advising your client to take a plea. So I think this actually is in violation of your professional responsibility.
I understand, Your Honor. This case is quite old. And
I recognize how old it is. That doesn't, the age of the case does not negate your responsibility to receive the discovery and review it with your client.
I understand, Your Honor. Does the court want to give me a date now, or will they just send me a notice?
Counsel?
I just wanted to put on really quick here, and I checked our system. The prosecutor's office did not receive an appearance from Mr. Lippett, which would explain why he does not have the discovery. If you were to file that with the prosecutor's office, then the people would be willing to send him all of the necessary discovery.
Your Honor, I filed my appearance with the court on on October 12th, 2020. And then I also wrote a letter to Your Honor on October 30th, 2020.
We have your appearance. The prosecutor doesn't have your appearance.
I understand. I wasn't aware. I wasn't aware that was a requirement, Your Honor.
Yes, you have to file an appearance with the prosecutor's office. We don't file them on your behalf. We only receive the one that you filed with the court, and we have your appearance.
I'll take care of that this morning, Your Honor.
August 28th at 10.
August 28th at 10.
Very good, Your Honor.
Any additional matters for today's record, counsel?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor.
You're all set for today, Mr. Martin.
Thank you.
Thank you, Your Honor.
Thank you. The record in the matter of the people of the state of Michigan versus Ramona LaShawn Hunter, file number 23-01788, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Ramona Hunter, who is present and standing to my right.
Let me see if I can find this out, because we're a little early on that one. Very low. That's the last one, thank you. Okay. Ms. Hunter, how are you?
Hi,
How are you?
fine, and you?
I'm doing okay, thank you. Today's the date and the time that's set for a pretrial. I do have one count of assault and battery here. Was there an offer?
There was, Your Honor. The offer would be to plead to the charge of the Killebrew for no upfront jail.
Your Honor, at this time, with no offer, we would just be setting it for a final pretrial and jury trial. It's my understanding there's also a city case that she needs to be arraigned on.
Do we have that final?
And if at all possible.
Oh, the magistrate's gonna arraign her. She has a
Okay.
file.
Okay.
Okay, sounds good. Is it Magistrate Kelly doing it? That's why she was just here. Okay. Let's see.
We can do final pretrial October 16th at 8. Jury trial. For 13th at 8.
Wow, this, Final pretrial, October 16th, 8 a.m. in person at the court. If we proceed to trial, we'll schedule it now for November 13th at 8 a.m. Also in person in the court. Do you have any questions today?
No, ma'am.
Okay, and you're being held on what, ma'am? You're being held in Acosta, is that correct?
Yes, ma'am.
So not on this, okay. Any additional matters for the record today?
Nothing from the people, Your Honor.
Nothing from the defense.
Okay, you're all set. We'll get you a copy of your next notice to appear.
Thank you.
Are we ready? Who's representing Garza? Is she ready on him? Is Mr. Lee? Missing?
I'm representing.
Oh,
Jessica
I can't see him.
Gonzalez, Your Honor.
Okay, there you go. We're ready on Mr. Gonzalez.
Yes, Your Honor.
On the record, in the matter of the people of the state of Michigan versus Jessica Marie Gonzalez, file number 23-02346, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Ms. Gonzalez, who is doing this via Zoom.
I also have, oh, wait a minute. Who stuck this in here? Okay, she's got to turn herself in. I think it's a felony. Okay, Ms. Gonzalez, you need to appear in person. You have a felony warrant.
A felony for warrant for what?
For assault with a deadly weapon.
They told me I could appear on Zoom.
Not for a felony warrant. You're here today for a pretrial on another file, but we have a new file for you. So you have to turn yourself in to be arraigned on that, okay?
Oh, how long would I be in there then? What, I don't know.
You'll be arraigned within hours of you turning yourself in.
Okay.
We can't arraign you on a felony via Zoom though.
Oh, okay, wait, wait, am I going to jail when I come up there? Or,
You're coming to the court. You do need to turn yourself into the jail so that you can be arraigned.
Okay, I'll get ready and get there.
Okay, and then we have this file number 23-02346 SM. That's what you're here for today, and that's for a pretrial on a domestic violence. Counsel, was there an offer?
Yes, Your Honor, there was, the initial offer on this was a plea to the charge of domestic violence with 7694F eligible. However, with the people weren't aware, at least I was unaware at that time of the felony warrant, Your Honor, so that offer may change with the new felony case, Your Honor.
It is the same victim.
What's the weapon? I don't understand how I went after somebody
You'll
with a
find
weapon.
that's the whole purpose of the arraignment. They'll tell you all the charges. They'll read the charges to you at the arraignment, and then they'll give you a bond.
Okay.
It is the same victim. So
Ms. Gonzalez, you can call
your attorney, but until you come in, you'll be in warrant status, and you don't want to get picked up on the warrant because then you might sit longer than turning yourself in.
Okay. I'll call him and then I'll come in.
Okay, sounds good. So we need to reset this, or are we setting it for final pretrial?
maybe reset.
Reset, okay.
Yes, a reset would be appropriate, Your Honor.
We're gonna reset this and let me see. If she, when do you expect to come in to be arraigned on this?
As soon as I get off the phone with my lawyer or my attorney.
Yeah, if you can get here sooner than later today, because it's almost 10:30. You can get arraigned today when the magistrate does the arraignments.
Okay, I just don't want to miss work either. I can't afford to miss work.
Oh
either.
yeah, what time do you have to be at work?
Tomorrow at 8 a.m.
You won't miss work. If you turn yourself in and your attorney is here, if the magistrate's not able to arraign you, I can arraign you because I'll be here. But I can't do it over Zoom. I can't hear you, ma'am.
I'll give him a call and then I'll be in.
Okay, sounds good. If she turns herself in before this afternoon or whatever, just let us know. We can arrange it. And then I think if she does it today, she'll get a date within the next 21 days. I don't think you want to have this before her exam, correct?
Probably not.
Okay, we'll set this out 30 days.
October 2nd at 9:30.
October 2nd at 9:30 will be your next pretrial on this case. I'm setting it that date with the anticipation that you're gonna come in today or tomorrow to be arraigned, and that way we can have your next court dates on your new file before, because that's the more serious charge, before this one, and your attorney can negotiate or work out a global resolution if possible, okay? I can't hear you again.
I'm gonna come in today.
Okay, did you wanna go in the breakout room or you wanna call you?
Why don't we just go into a breakout room real quick? That's a great idea.
Okay, he's gonna get back on Zoom so you can go back in the breakout room, okay?
Okay.
Thank you.
This is Angela Garza.
Interesting. Let's see here. We did Stone. Oh, no, did I mess that up? We didn't see Stone. Let's see. We got some bench warrants. Let's handle this real quick. Anthony McCullen did not appear. Bench warrant. McCullen again. And McCullen again. Nicholas Stone failed to appear. I have 1, 2, 3, 4, 5 files for Stone. Bench warrant Stone. And then you have Garza with you.
Yes.
Record in the matter of the people of the state of Michigan versus Angelo Garza, file numbers 23-02490. Council appearance.
Jeff Roberts on behalf of the people, Your Honor.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Angela Garza, who is appearing and standing to my right.
Yeah.
Okay, today's the date and time that's set for both a pretrial and then a hearing on a probation violation. PA 53 was set, and he was arraigned on that back on the 15th. I think there was a bond set on the violation. It says the alleged violation is a violation of 4D, which would be not to commit any crimes while on release. Does he have a new matter pending?
Yes, Your Honor. He, what's set for pretrial conference today is actually a matter for a contempt in his felony file, which is set for a contempt hearing next Monday at 10:30 a.m. Yes, he has a new file that's set for pretrial next Monday at 10:30 a.m. That is the basis for this contempt on this file.
He has another pretrial next week, you saying?
No, he already pled guilty to something. So yes, next Monday at 10:30 a.m., he has a contempt hearing on the felony matter, as well as a pretrial conference on that new case.
It's a felony? I'm confused.
Well, he pled guilty to a misdemeanor, I believe,
Oh,
Your Honor.
okay.
He was supposed to be at sentencing on August 10th, in which he failed to appear. So now it's set for October 13th.
Sounds good. And then there is a breaking and entering illegal entry in this matter. How are we proceeding on that?
Yes, Your Honor, at this time, the people have not extended an offer due to the new case and the pending bond violation. So I believe the parties at this time would ask for a reset of this matter in order to possibly facilitate a global resolution of all of these matters.
He has a court date before me next week,
Yes, Your Honor.
so we'll reset it till next week. Do you have any questions today, sir? I'm sorry?
No, Your Honor.
Okay, any additional matters for the record, counsel?
Nothing from the people, Your Honor.
The only thing, Your Honor, being that on that felony file, he does, these files, the 10% or cash surety bonds have converted to PR, but on that felony one, it's still a full cash surety 3,000. He does have a stepmom in the area that he would like to be released to. I didn't know if it was possible, like I said, for the felony, but she wanted, put that on
So
record.
you're making a bond motion on the file, the felony file?
If it's at all possible, Your Honor.
I have to see that file. I don't know what's going on.
So I the files for Wallace. They said the only copy is in file.
You said that this are converted to a PR, just not for Borrego. How did it get PR?
I was looking online, Your Honor, on the jail website, and I'm only showing 3,000 cash surety on the fleeing and eluding felony. Yes.
Right, but they gave him a bond on the violation.
Oh, they did? Okay.
I must have just given you that file. Did I just give you that file? Yes. Yeah, I think there's a bond. There's a 510% bond, I believe. I could be wrong. Yeah, they gave him a 510% bond on the violation back on the 15th of August. The original charge sheet was already a PR. And then I'll have to see the other file if I get a address bond. So can we get a security officer in here to relieve you, Mr. Bengals, you can get the file. You can have a seat, sir.
Yes, Your Honor.
Davies is in custody, though, correct?
Yes, and you should just be appearing by video.
Right. What happened? Oh, you have it?
Yeah, I apologize. I was looking for the MC 512. I didn't know that there was a different supplied.
Oh.
And Jody had said she put it in the court file, but.
Oh, he has an attorney.
Yes, and there was not a completed MC 512. This was the only motion.
It's gotcha. The attorney should have known that he was supposed to serve a copy of this on the prosecutor's office. Because then he gave him, it was 14 days to respond.
In the prosecutor's office is listed on there as noticed, but.
Right, this was filed July 19th, I believe, or around that time, so I don't know, maybe if they sent it to the wrong person, Mr. Bartlett, I don't know.
Possibly I can check with, I know, like, you've noticed, as you've noticed, Your Honor, that it's kind of a jumble in here after Mr. Ring left. So I can check and see if anybody else in my office received it via email. But if they did not upload it.
Okay, you can come and get this copy here, though.
Oh,
Thank you.
sure. And I'm checking my emails, and it doesn't look like prosecutor's office was
CC'd on that?
No.
Okay,
Not
sounds
that
good.
I see.
I don't think that if you reviewed, I don't think that there would, I don't believe that's something you would object to, but you might know something. I
I'll
don't know.
review it this morning, Your Honor,
And I did include documents in the court file of everything he's completed, if you want copies of those as well.
Right, I seen that, and I saw
Okay.
they said everything that he was completed.
Yeah.
So,
paid in full.
I just didn't see the motion.
Got it. And do you guys need a copy then for the court file, or is
So
there?
he's gonna give us that one back.
Okay.
We'll make a copy.
All right, sounds great.
Thank you.
Yeah, no worries.
Thanks.
Yeah.
4906.
What you want, name?
Mona.
Andy?
Handy.
Art?
It's hard.
yeah. I don't see, could I get a copy of this, Your Honor?
Yes.
Okay. And then,
Yeah.
while we're waiting on that file, just really quick, Your Honor, did you bench warrant Mr. Stone?
I'm sorry?
Did you bench warrant Mr. Stone?
Yes, Mr.
Okay.
Stone is bench warranted and McCullen is bench warranted.
I caught the.
Sorry, okay, they're in the file, he's in the file for sentencing. You said what?
He said he's getting the, niggas getting the file for his sentencing.
Is that what it is, the sentencing?
Yeah.
I'm
His
not
felony
sure.
File was, he just didn't show it. So we had to get another attorney.
I don't, was he on bond on that one?
Yeah, so he put it and then.
He didn't appear, so they
Yeah.
gave him a bond. Got it.
Did you?
While we're waiting for Nick, would you mind making?
He's right here. It'll be faster if he goes to commercial.
Yes,
Okay, thank you.
And so you said,
Oh, they do.
to be the pre-sentencing report and then you missed the appointment. So you started your pre-sentencing.
Oh, they did. Okay.
Are you information?
No.
Contact information.
Okay, in this matter, we've gone over. File number 23-01174, people of the state of Michigan versus Angelo Garza. The bond was set on August 15th for $3,010% because of his failure to appear.
Also, Your Honor, it's my understanding he failed to appear for the pre-sentence interview. So my understanding is he would need to be able to complete that as well.
That is correct. And he's going to appear multiple times on this file. It's a pretty low bond, at $3,010% for someone who doesn't come to court.
But I just wondered if there's any chance that that could be converted once he gets the pre-sentence interview.
Oh, yeah, once this interview is completed, I can absolutely convert it, so long as he believes or he ensures he's gonna come to court.
Yes, ma'am. That'd be this coming on Monday, right?
Well, you do have a court date on one file. It's coming up Monday. This file, though, is the one that you failed to appear for your sentencing and your pre-sentence report. Interview was not completed.
Okay.
And so we had to get you a new referral. So you still have to meet with our probation department, and now your sentencing on this matter is scheduled for October 13th at 8:30. And you should have already received a notice for that. I'll note that here in the file. Any additional matters for the record today?
No, Your Honor.
You're all set. You're gonna log babies in. I presume.
Yes, Your Honor. And when he does, I'll need a breakout room with him.
Sounds good. That's all we would have for the morning until 1:30. After that one, if Ms. Gonzalez appears, we'll take care of that.
It was sent, it was sent to the prosecutor's office, July 27th for.
All that motion was sent to the prosecutor's office on July 27th, Mr. Brodowitz.
All right, I will track down who had it. I don't, as you stated earlier, and I don't see any, I don't really foresee any objections, but